Hello, all, and thank you so much for joining us. This is another week of a very, very exciting seminar putting together today of how to navigate complex cases. And I'm Traci Kaas. I am the author of What You Can Expect When Expecting a Settlement. I am a 16-year settlement planner, financial advisor, and certified financial transitionist. For all the attorneys out there, there's also case settlement guide, case reference guide. So for you as well. So what to expect when expecting a settlement was my baby after all these years to help the claimants learn how to make their own decisions when they're settling the case. And today I feel incredibly lucky to have one of my very best and favorite firms, mainly not because of production and amazing cases, but just because these people walk the talk, and they're absolutely wonderful with their clients. There are certain firms that put the client first, and this is one of them. So I'm very, very lucky to have two people from the Aitken and Cohen firm, as well as a legend. I don't think that everybody like me gets a legend on our Zoom, so I'm pretty privileged with that. So introducing first Wylie Aitken, and Wylie is nationally recognized, and there probably isn't an award out there that Wylie hasn't already won. One of the things that I learned that I didn't know before, Wylie, is that you were the youngest president of the State Trial Bar Association. That was a fun fact that I didn't know. And I can't appreciate enough the charities that you're involved in, the charities that you start, how you really give back both in your personal life, in your professional life, and how you are that same person, no matter what role you're in or who you're talking to, and you've never not given your time and your expertise to the people that have asked, for you. So thank you for being here.
Well, it's a pleasure to be here with you, Traci, and I'm gonna knock that halo off my head so we can get started here with the program. And I have read that book that you were flashing there, and it's terrific, and I commend it to everyone because one of the things we do want to emphasize in today's presentation is that there is the legal side, the side of where we try to develop with creative theories, do the best possible representation, and then there's the human side of cases and caring about them on a very personal basis. And we know some of the sad stories if they don't manage their money correctly and what happens. So it's the total package that I think lawyers sometimes shy away from, but I know Chris and I would encourage them to be very much engaged, because the ending is as important as the beginning and as important as the middle. So that's something we'll be talking about here today. So I guess we'll initially kick off with a series of cases that I think illustrate the points we want to make today. I'm not sure what time it is, what day this is. This is COVID-19. It could be a Thursday, it could be Sunday. It's hard to say, and they all seem run together and different, but we'll get through all of this together, including the program. So initially, let's start off talking about a case that was just so incredibly tragic that I sometimes can't get through the story because it is such an amazing, incredible, gut-wrenching story. It involves the Vigo family, and some of you may have heard about this. This was a case that occurred back in January of 2011, and amazingly enough, I actually read about this case in the newspaper and couldn't believe the facts, and never thinking I would ever become and have the honor with our firm to represent the family, but it turned out that was what happened. And in this particular instance, on a morning in the Inland Empire in San Bernardino, California, a live 12,000 volt wire dropped into the backyard of an unsuspecting family in early morning hours when it was totally dark. Before the end of that morning, we lost 3 members of a family, leaving 2 children with the loss of a brother, loss with both mother and father, all because of, frankly, a story that had Southern California Edison imploding what happened. And a theme behind this case, and you always say, what's the theme? The theme really had to do with the fact that San Bernardino in the Inland Empire, where we have an office, it gets neglected. It's Southern California. Edison picks and chooses where its resources go, and the power lines in that area are old and worn.
Oh, lost him for just a second there. And as Wylie comes back, this is one of the cases that kind of hits home. And I'll talk about it a little bit more in the end. But when I read this is, if I had top five. Keep going, Wylie. You froze for a minute, so.
Oh, okay. So maybe I'm talking too fast. But so what we're looking at here is, if you look at this particular photograph and outline, you see the home of the Vigo family. You see the wires, the yellow one on the right, the yellow 4 wires, they were worn and they were allowed to sag, and the sagging becomes really important because they're designed that these wires cannot come in contact with one another. But if you allow too much extension, too much sag, when the wind comes up, they can then touch each other. That sets off an explosion and sets off an arc. And in this case, the wire broke and fell into the backyard of the Vigo family. So you had a young father of 44 years of age, a young mother of 23 years of age, who walked out into the backyard. The father initially, because it started a fire, and it also started a fire in the front yard. So mom goes to the front yard, dad goes to the backyard. And in front of 3 children, the father, as he's walking in the dark yard trying to figure out what started the fire, having no idea it's an electrical fire, comes in contact with the fire and is electrocuted to death. Mom rushes out to save father. She touches him. She is electrocuted. The son goes out, the oldest son, who was 17 or 19 at the time, runs out to save mom.
We had a little flash there. He'll be back. And this one, as
mom and dad, and he okay, am I?
No, you're back.
Okay, now, so I don't know how much has been missed.
We just said mom and dad, the brother ran out as well. So the brother had come out, and the 2 young children were watching this stuff happen as they ran out. And
okay,
keep going.
I'm just interested, is this a connection on my side where I'm somehow dropping on and off?
Yeah, but it's okay. Keep going. Well, we're picking up when you drop off.
Okay, well, all right. Anyway, so what's interesting about this case was, of course, that it's incredibly tragic. As we dug into it with the experts, the liability of Edison and their whole business operation came into question. And I want to share with the audience here, there is what they call a general rule called GO 95 that requires certain responsibilities of the utility companies. And what's totally unique about it, which they violated at many different levels in this case, failure to have a backup system, failure to realize and cut the power when they first showed up on their grid, and all the other things that happened. But GO 95 has a very interesting, it has its own punitive damage provision, so that one of the weapons that we had in representing the family was to not only show the terrible, horrible tragedy that these 2 young kids suffered, suddenly becoming parentless and losing their older brother who they could rely upon. Then they were in a situation where we also had the argument for punitive damages, because it's a separate punitive damage section from the one that many of the lawyers listening are familiar with. So if we could go to the next slide. This takes you through events of that particular morning. I've pretty much outlined them, but if you look at this, you see that it happens at 5:41 a.m., total darkness. When he walked out there, there was like a snake in the grass that was as deadly as could be, but he would have no idea that that snake wire was live and could not even possibly have seen it. There was an incredible delay in getting anyone out there. The fire department arrived very quickly. When you look at developing a case, we had the 911 phone call that the young daughter, who was only 17 years of age, made into the fire department. And we had the text of that, which was it's so powerful and so moving. I can hardly deal with it whenever I listen and read what this young girl's desperately saying over the phone and the questions that are being put to her. But the fire department arrives very, very quickly. The police department and the fire are out there at 6:23, but it's almost 45 minutes later before anyone from SCE even arrives. And the fire department and the police officers appropriately were not running out into the yard and were basically prohibited from going in and providing necessary rescue services until such time as somebody from SCE got out there and de-energized the wire. So that's the context of it. There's also, let me see the next slide if you would.
And that was for me, that was just, yeah, separately from being complex, that was probably the most horrific 911 text that I've ever read. I pretty much cried during the entire thing because it was so long. And as they were on the phone with her until emergency units were there, and it was just outstandingly horrific.
The text is extremely powerful. I guess if you think about exhibits, but setting aside the text for a moment, we have the actual recording itself. Mm-hmm. And of course, the picture worth 1,000 words, the actual words being spoken on
the 911 tape, yeah.
Real time. It lacks, that's the situation with the another thing that, of course, it's probably the most terrifying case of bystander liability and damage that I've ever heard of. And that is that they watched this all in real time, these two young kids. And of course, it's scarred them and marred them forever. So the PTSD and all of the workup that was done beyond the loss of care, comfort, society, and love of a father and a mother, if that's not enough, it's with the personal emotional trauma that these children would be carrying throughout the rest of their life. So ultimately, we were able to resolve the case for $12.5 million per child, a $25 million settlement after extensive litigation and mediation in front of the great Justice Jack Trotter. And we got it resolved. But then, of course, the important part is how to protect these children who are now basically homeless, not so much homeless, they were with their uncle and aunt, but how are we going to make plans? And that's where Traci comes in and does an amazing job. So I'm going to turn it over now to Traci to explain what she did and what the challenging issues were.
Yeah, thank you. So Wylie, one of the things that's so appreciative about what your firm does is that I'm one of the team, the trust. You guys did an amazing job making sure that they had the proper, counseling and stuff too. So I know that even Stephen had been with a counselor for many, many years. So there was ongoing connection. There was an ongoing relationship. This wasn't a case that was just done and over for your firm. You guys have that relationship. And so it's very appreciated. And I know the family does too. This was a little more complicated. There were 2 children. I'll talk about Stephen first. Great success story. He obviously had a lot of emotional, will always have that PTSD. And when we put this plan together, one of the things that was important is the demographics of where they lived, and the type of community that they had. So one of the things that we did is we were able to move them to Orange County and to be in a school district in a system that going to college was something that you just do. It's part of the plan. That's what all of his friends would do and such too. Because he was 11 years old, it gave years and time to develop those habits of, education is important, studying is important, because we needed to set up a plan for the future. So in my world, I had, a 7-year window to help groom and, help this family move along so that when he turns 18, he was able to manage his own affairs. And in this particular case, we set up a minor's trust. At the time of settlement, we did a minor's trust. A minor's trust is actually not that easy to set up. For most of you, if you've ever tried it, it's not something that's looked highly upon with the courts. I think generally, in a lot of cases, they want to just take the funds and put it out till 18 into a traditional structured settlement. That really wasn't the best option for this family. So we were able to set up a minor's trust originally. It was court supervised until 18. It was documented that at the age of 18, he could revoke the minor's trust, and then we put it into a living trust. We also created guaranteed income so that he was taken care of for the rest of his life. However, we also had good expectations to do a lump sum, as you can see here, so that way he had that flexibility to purchase businesses or help him with college. And so we created quite an extensive plan. I'm happy to say that he is actually now 20 years old. And so we've been managing the money for the last couple of years, but also creating that relationship with him. He makes all of his own decisions at 18 years old. We're having conversations about taxes and what they are. Because of the size of the amount that he has, we do have tax consequences, which is a good thing in this case. The home has grown in value. He's actually in his 2nd year of college, although doing homeschool college, but he's actually in college. He's managing his own affairs, and he's only purchased one $50,000 vehicle, has no fancy tastes. So it's been quite lovely to watch him grow. On the flip side, Chris, if you want to switch to his sister, this one's a little harder. And this one took a little bit of careful planning and a lot of teamwork. I know Ashley Aitken helped a lot on this case too, because she also had the relationship with the family as well. And Ashley and I had a good conversation because Kaylee at the time, she was close to 18, and there's a little typo there. She was close to 18 years old and did have the ability to, take the funds and do whatever she wanted. However, we created what was called a irrevocable trust until she is 27 years old, and then it actually changes, until she's 30 years old. And then at 35, she is the full trustee of it. So it gives us a little bit more time to work through it. She did have a few different issues that she needed to work through. We're still working through some of those issues, but because we had the foresight of wondering if this was going to turn out as well as her brother's plan, so we did the careful planning to create a lot more lifetime income in this situation. So we were able to create, as you can see, a staggered amount of money coming in, and you can see it's quite significant. What by the time that she's 35, it's added up to quite a bit of money. But this one takes a little bit of diversification, a lot more guarantees, a lot more protection and creative planning with the use of a irrevocable living trust, which is not special needs, which was not a minor's trust. So this one was a little outside the box planning as well. But again, it took a team to put it together. So that was kind of this. So Chris, we didn't get a chance to really get you introduced, but Chris is been with the firm, obviously, for an attorney for over 25 years. I kind of consider Chris a little bit of the quiet one that a lot of people don't hear or see him quite as often. However, it's amazing the work he does. Chris is very meticulous with his cases. He knows them inside and out. And the dedication that he has to his clients is just amazing and outstanding too. Chris has always been just amazing to work with. And I'm super happy to talk about a couple cases with you, Chris. So I'll hand it over to you.
Thanks, Traci, and good morning, everybody. I appreciate you attending. Yeah, I want to go over a couple cases initially here. These two cases actually involve a form of a skylight, and the first case that I want to introduce to you is we represent a young man named Ryan Corbin. He is the grandson of the, as you see there, the noted singer Pat Boone. Ryan, kind of basic facts of this case were that Ryan, preparation for his wedding, which will be in a couple months, went on top with a friend of his Santa Monica apartment. It was a multi-use, multi-apartment building for sunbathing. And in doing so and coming back from the sunbathing, he did a misstep onto what looks like a skylight. It turned out to be corrugated fiberglass, fell 30 feet to the concrete and had a very major brain injury. So those are kind of the basic facts. I will, one of the challenges of this case was, and this was the entrance to the apartment building. One of the challenges is that the area was, it was not its intended use. So if you look here, this was the entrance to the, where he was sunbathing, and it was a door that was left open. And so when we got this case, one of the challenges we had to face was this. And what we learned is up in Santa Monica, and certainly I think it's also very common in San Francisco, people would go on top of their apartment buildings, on top of their residences, and they would do sunbathing. And through, in essence, deposing many of the apartment buildings there, of course, and the building owners, we're trying to establish notice, because there were people that would use it. The owners say they were not aware of it, but our client and his friend were not the only one doing it. But so one of the challenges we had was, trying to develop notice, which we did, and really kind of get through some of the liability issues as it relates to what a jury would think of, of him going up there and using it for sunbathing. So one of the things we try to do, and is, this is kind of a side view. We actually ended up turning to animation, and one of the reasons we turned to animation was, frankly, trying to present in a way that make it a little bit more attractive, a little bit of being a little bit creative. And what you see here is if you look in, you see the lighter brown material that was really a trap door to a concrete 30 feet below. Again, it was corrugated fiberglass. Corrugated fiberglass is not intended to be used as a skylight. And skylights have very specific codes. They have very specific standards. And so we went up there and he stepped on the side of his corrugated fiberglass. He literally went right through. If you did that on a skylight, if the normal skylight you're aware of, that would not happen. So we tried to, in essence, through the gift of animation, try to make a picture that it certainly was much more of a, attractive place, for lack of better words, to sunbathe. And again, we did develop notice through the case that they were not the only ones doing this, and which became very convincing to the defense. Also using experts to develop that, skylights have very specific standards, very specific codes, and this corrugated fiberglass did not match up to that. One of the things, whoops, sorry. One of the points that we tried to make, in essence, is that within a mile, you could find, at the local Home Depot, if the building owner, would have bend the code, you could find a very simple solution. Go to your local Home Depot, you know, spend a couple bucks, less than $100, and you find a qualifying skylight that could have been there. And if this skylight was there on the day of the incident and Ryan did a misstep on this, the accident would never have happened. And so it kind of goes to, there are some real world things you can do. I'll talk about that a little bit later. Another case I dealt with called Bucket, but it's just kind of a simple point that, you know, if the building owner would have just gone to local Home Depot, Ryan would not have suffered the major brain injury that he did. One of the things I wanted to introduce is that we were representing just an amazing family. You know, we were able to get, you know, an 8-figure result on this case. And, you know, with the resources that the family had, they were able to establish a foundation that we've been involved with ever since called Ryan's Reach, which I really would welcome everybody to look at and support. One thing is that the issue with the brain injury, and I think, you know, Traci, I know you're well aware of this, is that the support for a brain injury can be very limited in counties. There is a need.
Absolutely.
You know, there's who they worked with. One in Orange County is a rehab center called High Hopes, which are still involved with. But you know, through the result, they're able to establish Ryan's Reach, and actually have made different residential places for families of need. Because one of the big issues in the brain injury is that, you know, this allows the family, it's a 24-hour thing, and it's a 24-hour care for the family. And so allow the family, for instance, even have a week of time where they get full care when they don't have the funds to do it. It's, you know, it's really, as, you know, tragic as story this is, I have to tell you, I'm not sure if I've met a family quite like this that would do such good for the needs of traumatic brain injury here.
And they do. And I think one of the bigger points with that is, you know, they push to create a place where, because a lot of, when you have a TBI and you're young, they put you in a center where everybody is elderly, generally, dementia or those types of things. And so I think working with High Hopes, I think it's a place where they can go at a younger age. So they're not in feeling like they're looking with their great grandfather or something like that in the facility. So it's an absolute outstanding, amazing thing that they've done, and that coordinated in with what you guys did for them.
Yeah, thank you, Traci. And so it's, you know, we're, you know, obviously we're proud of the result, and you know, this is a great family doing great things with resources to help others is example of this case. The other case I wanted to talk about as well is a young man named Garrett Poor. Garrett, it's similar but different. He actually went on top of the area that, you know, that had railings that on the second level, as you see these green railings here, and climbed over the railings and stepped on the skylight you see at the bottom picture here, and fell through and suffered also a significant brain injury. One of our arguments was basically that, you know, the owner was placing different things up there. As you see, there were chairs, there were different things that would attract someone to go over that railing, such as a young boy that would happen here. And Garrett certainly did do that, and he came over and he stepped on the skylight, and the skylight itself, due to the sun exposure and due to being old and frankly not being maintained, Garrett went right through. You know, if the owner, much like in the Corbin case, would have simply maintained their premises, we argued, you know, and Garrett stepped on its skylight. Skylights are actually designed to withstand weight. This skylight did not. As you see, Garrett fell right through. So in this case, Garrett did go along. This is a alleyway, you know, that on the Green Whale. One of the challenges we had was that, you know, he did climb over the green railing, which, you know, was arguably at code. So they did present an argument that, you know, they had the right railing, but, you know, we were able to successfully get a significant result in this case for Garrett and the family due to the fact that, you know, the maintenance of the skylight, and to the fact that the owner did put out, I guess, whatever, for lack of better words, an attractive nuisance, and Garrett suffered a major injury to this day. But we did, I worked really closely with Traci, and Traci, I'll turn it over to you because, and just want to impress on everyone here, the level of care that Traci gives her clients. I mean, Traci, it's not like when we kind of worked up the plan with Traci on the poor family that it stopped there. I mean, Traci really got to know his family and do the family's needs for a long time. And maybe Traci can, and this is Garrett here, unfortunately, in the hospital, but maybe Traci, you can kind of talk about that now.
Yeah, great. Thank you, Chris. And gosh, I can't remember. He was so little back then. He's actually a big kid now. He's 24 years old. One of the things that Chris, to say another obstacle is really to emphasize is Garrett's autistic. So Garrett is highly autistic, and so he is kind of like remember the movie Rain Man, where he repeats himself, needs 24-hour supervision as well, and that was something else that you were able to overcome on the settlement. One of the things with Garrett as well is that the family had a concern for even the well-being long term. So one of the things that was a little more unique in this one, we did do a special needs trust. We did make sure that the family was reimbursed. We did reimbursements, so we worked closely with the family to find reimbursements. The reason I really pushed for doing that extra paperwork and doing extra declarations for reimbursements was I needed the family to do their living trusts and do their estate planning. A lot of times clients don't know that if you have a child of special needs, if we do all of the work to do the plan to protect the child and keep their benefits in place. However, if you lose a parent and the assets default to the child, we've now lost the benefits. So when we were putting this together, it wasn't just the settlement itself. I needed to take a bigger picture and look at the parents and what their needs were. How do we protect the family in whole? And one of the things that we did is we made sure that the parents got their estate planning in place. We also put a life insurance policy that the trust itself actually makes the premium payments to then pay for the life insurance premiums, so that if anything should happen to his main caregiver, his mother, that there's also a big infuse of cash long term. Garrett's been doing amazing. We're super happy that he loves going to the gym. He hasn't been able to do that so much with COVID, but he's just fun to be around and quite entertaining. But so this one took just a little extra planning again that was not inside the box, so it was quite outside the box. So Wylie, let's kick back to another case that we, again, I have favorites, that word favorites. Love the favorites, and this is a fantastic and very, very interesting case. I know the entire time that we were going through, I did attend the mediation on this one, and I found it very riveting, and just the back and forth, and I think that the result was outstanding for what could have happened. So look forward to you explaining this to everybody.
Well, thank you, Traci. I want to make a couple of quick observations. One thing we do in our law firm is we work closely together as a team. So even though I'm doing the talking about Marty O'Connor, which is a great story in of itself, this is a case I worked very closely on with Rich Cohn in our firm. And of course, worked with Chris on the Corbin case, and my daughter, his sister, Ashley, worked with us on the Vigo case. So one thing we like to do is have a partnership. So Chris and I get to do all the talking, but we want to thank everybody that's worked right alongside of us to make these results. I was listening to this presentation, and sometimes you have that slight tendency to say, well, this case has a happy ending. Well, happy ending is a very limited term whenever you can talk about the serious and permanent injuries that we deal with and the permanent effect it has on the family, but it does show the resilience of the human spirit. And one of the great stories is Marty will come in, restaurants are, and a big gathering place. Well, by the end of the evening, he's going to take a break and they're going to gather up and go home. Well, what you're seeing here is a metal stairway, a replication that actually is tied in with a place called Sid's Blue Beat. And he sat down there and one of his, to kind of gather himself. And we had kind of two interesting aspects of this case. We started out looking at it as a premises liability case, and then we turned around and refocused. Not that we always thought the products case has to do with the fact that these old metal steps were very not up to code. They somehow got grandfathered in because they would have never been approved in any kind of modern law that we know of. And but our real problem was that he sat on there and then he apparently fell off the steps and then hit his head and then ends up prone on the ground.
And so, Wylie, to interrupt for just a second, you had froze for a second just to get the audience caught up. He had been drinking with friends at a bar, and that had happened and then had gotten him to the steps. You had frozen up for just that second as to how he got to sitting on the steps and what his current condition was at the time.
Right, exactly. And of course, I wanted to note that that's kind of the culture that goes on in that area, because the culture of the area and how the police deal with it became a significant part of the case. Mm-hmm. Long, sad story short, he falls, he injures himself. He's got a fractured neck, not a fracture. He's got a herniated disc caused by it, along with a significant head trauma. And of course, what happens is along comes the police department, who would just assume, oh, it's another young person who's had too much to drink and is now fallen down on the ground. And they don't realize they're dealing with a very serious and difficult problem. And they don't realize it because they don't bother to care and they don't bother doing anything about it. Then, of course, they call the 911, they bring out the paramedics. He's had too much to drink. And so they leave him there and they go to the apartment and make sure that he's comfortable, and then they leave, not realizing that what is going on here is a form of now turning.
And I know that cut off a little bit, but he had went home with his friends versus going with the paramedics, and his friends had tucked him into bed.
Into somebody. And the reason he went home with his friends was because they would not take care of him. You see at the next slide, this is what should have happened. He should have been all the safety precautions pulled together, loaded into the ambulance, taken to Hoag Hospital, and this tragedy never would have occurred the way it in fact did occur. And so it's a total missed opportunity, totally callous in reality, because you had the city of Newport Beach, both by their paramedics and their police, totally mishandling the situation. And then of course, the effect of it was permanent quadriplegia for this young gentleman. So you can see that's what we were dealing with in this case. The next slide is a picture of Marty as he's finally gets to the hospital where he belongs. The next day they realize, and his dad has to come to the apartment, and they finally get him to the hours later to the hospital, where he finally gets the appropriate treatment. But it is the classic story of too little, too late. Now he's a permanent individual who has been had his life turned upside down. But let me let's show the next slide, because there's always the legal side and the challenging legal issues, which were multiple in this case, because it converted from a premises liability to basically a medical malpractice and failure to provide emergency medical care by the city of Newport Beach. But now what you see is we were able to, if you look at this slide, here is Marty, who puts himself back in school. He gets a graduate MBA degree from Chapman University, of which I am most proud. And he, not only that, he comes from a marvelous family. And that is his lovely mom standing next to him. She took him to class every day, made sure he was able to get through the graduate program. They allowed her to sit in the classroom and to be of assistance to him. So she became his caregiver, his co-student. And what happened is he graduates from Chapman, and he's now gone on to a career in the film industry, and he's also started his own charity. So it's an amazing end to this story, but one I guess that is so special to me and the people who know the family is that Chapman then awarded an honorary doctorate degree to his mother. So she got her honorary degree at the same time, and that was a total surprise. So you can imagine mom so proud of her son up there getting a college MBA degree, and then suddenly she gets called up and is given a honorary MBA degree herself from Chapman University. So it is certainly heartwarming. And again, none of this can happen without looking at the human side of a case versus the legal side of the case and giving equal attention to both. And that, of course, is where our good friend Traci Kaas comes into play, because after the settlement of $6 million, now what can we do to ensure the future of this young man, and of course provide the resources to go to Chapman University to get an MBA degree, start a business, his own film production, etc. So let me turn it over to Traci.
Yeah, thank you. Thank you. I had literally had goosebumps again when you were talking about his mom getting the degree as well. This is just an amazing family. That this was definitely, it took a tribe. And for all of the brain injuries and the quadriplegics and paraplegics, the stories that are just absolutely outstanding are the ones that have a very strong family and a tribe behind them. Wonderful, wonderful parents that actually lived in Florida when this had happened and moved to California to be with Marty, and still today live in California as well. So with Marty, we did do a special needs trust to protect needs-based benefits, but he also had a work-life history. So with Marty, we needed to take into consideration making sure that we covered his future Medicare issues. One of the things about this one, and I kind of made a note, I think a lot of attorneys out there get nervous about dealing with a Medicare set-aside. There are a lot of advantages to getting that done pre-settlement, but also in this particular case, the Medicare set-aside, the future medical care, remember the attendant care would be the highest, but his future medical was over $500,000. But by doing the Medicare set-aside and the proper reductions and such, we really only had to put $108,000 of his settlement aside. So that was so we wanted to be very strategic about making sure that Marty was protected, both with needs-based benefits and entitlement benefits, such as Social Security, disability, and the Medicare. He purchased one of the best, what's called an MV1, a vehicle that a lot of people don't know about. It's built from the ground up for a wheelchair, but it's just fun to plan because Marty, being 27 years old, and you saw he's actually very nice looking, he wanted the hottest vehicle. So we made sure we got a black on black with good rims and such too. So just sometimes you take the small stuff into account as well to make them happy. But I've been along this path, sorry, my lights are off, this path with his family all along. He actually is incredibly healthy. He, as Wylie had mentioned, he started his own film production company. He has his own charity. He can't sit still for a second, and he even has a gorgeous girlfriend, at this time. So if there is any kind of success stories in the sadness. It's with somebody like Marty, and the attitude and just the energy he has is just contagious. So again, very privileged to work with this family. Chris, I wanted to kind of go into another case that's quite interesting to talk about.
Yeah, thank you, Tracy. So we had this case that I want to talk about had several different factors and some complexities that I wanted to share. The basic facts of this case was a young boy named Jacob Bucket came into a major fast food chain with his father. And like a lot of major fast food chains, they have these playground structures, indoor playgrounds that to attract kids and families for their product, obviously. And so they came in, and Jake went over to this play structure. What he ended up doing is if you look at the left blue pole, he climbed up that pole, and if you look under the little toy cars on the top of it, there's a kind of a monkey bar arrangement there. And he went up there and he fell. And when he fell, he didn't fall onto the padding below. What he did is he fell and hit the white tile. And in hitting the white tile, Jake suffered a significant brain injury. Those were kind of the basic facts of the case. There were two things that we were dealing with. One was, the fast food chain was making a point, in essence, that this was kind of a standard structure. The poles are not meant for climbing. The bars are not meant for climbing. They had signage there, and et cetera, and that they had padding. They had padding below. So they were basically indicating initially that their indoor playground was appropriate. The other issue was this fast food chain, like many fast food chains, was a franchise arrangement. And the franchise corporate, who had most of the insurance as relates to this case, was saying, hey, you know what? These franchisees, they do what they want. We don't control their actions. They do what they want. And so, what we had to do to develop through a lot of depositions, et cetera, and it was to establish, in essence, that, no, that's not true. The franchisor, the fast food chain, has a lot of control, a lot of influence on what these chains do. And they did have a relationship, and this company that designed this particular playground, was one of the preferred vendors of the franchisor, the fast food chain. And also, as the franchisee owner, he owned a lot of these different kinds of restaurants, said basically, hey, you know what? I think he said they control everything from the lettuce, tomatoes, and the pickles to my burger. And so so through that, the way it works is we had to establish some control of the franchisor to establish liability on them, along as the local one. This case was venued in Riverside. So we did a lot of discovery out there, and as relates to this case. So some of the factors, as we're through the development of this, we're trying to make some simple points. This is what Jake was climbing on. And if you go out there and, people have young kids, certainly I did at the time. I actually had a child the same age as Jake. This again was, looked like a monkey bar. So when Jake went up there, he was going up there and he thought it was a monkey bar. And when you have a design for young kids, there's ways you can design around this. And you see that we tried to make some real life examples to show that this indoor apparatus was not, that it was actually could be very expected that a young boy could climb up there. If you look at the pole that he climbed up on, there are certainly playground poles that are like that. So that, what was so unusual for Jake to climb up this pole to get him to that area? There was a maintenance issue on his pole. You see that the foam on his pole was a little bit ratted, which made it easier for him to climb, as it turns out. But the real point here was it was not unexpected for a young boy like this to climb up and get on the monkey bars. And unfortunately, this had a bad landing on the white tile. You know, another thing we learned through discovery is, and certainly as you analyze these playground structures, they all have codes and standards as well. And you know, as we basically went to a lot of the local ones. From what this one happened to be in Temecula, we went to Orange County, we went to Riverside, and looked at some of the other ones that some of the other preferred vendors that a franchise or did, and you see a completely different design. You see netting, and what the netting is in essence is to prevent this kind of climbing. Look at the height of this particular one. Look at the safety of this young boy in here that really doesn't give him an opportunity to climb. Look how it's enclosed. This one also had white tile, but it was enclosed. Look at the signage. The signage was much more complete and talked about no climbing, when the signage, we argued, at the one in Riverside was not sufficient. So through this, you know, and kind of in essence, you know, developing the liability issues, which certainly were some challenging liability issues, and certainly dealing with the control elements, which is the franchisor-franchisee arrangement. We were able to get, you know, a multiple eight-figure award for this family and create a major annuity to take care of this boy for the rest of his life. But so I want to kind of share this with you as far as somebody's navigating these complexities and kind of go from there.
Yeah, and this was a very interesting case as well. Instead of getting into the planning part, there is one more case that if we have time, Wylie, if you'd like to get into, is Summerall. I think that this is a case that has a few different pieces to it that I think the audience would find incredibly interesting. If you want to go over that.
I think it's significant, despite the fact that it has a picture of me here. What it really does is it shows how we work as a team. This is a case that came to our office from John Adams, a very good lawyer in his own right, who worked with me on the case. The case was on life support, about to be dismissed by the trial court. It was a major injury involving a motorcycle that ran into a vehicle that made an unsafe left turn in front of it. We also had Megan Dembski of our office, very active in Riverside and Inland Empire, work with us on the case, along with, I guess I just have to give a special tribute to Bill Copenny, who was a dear friend, and we lost Bill a number of years ago, and he had just finished the appellate brief in this case when he died during his sleep. So this was all part of a team that took a case into a $9 million recovery for the client after the case had been dismissed by the appellate court, not by the appellate court, excuse me. It was dismissed by the trial court on motion for summary judgment, telling us that we didn't have any case at all. So we had a zero offer that turned into a motion for summary judgment, and now we have to go on appeal. And so let's go to the next slide if we could, because this case is so important to all of us who struggle with having strong cases, but no resources in which to pay the judgment. In this case, the gentleman who caused this injury was a cement finisher who was on his way to work. So we all know there's this famous exception if you're on your way to work and it's just a going and coming rule, there's no liability for the employer. And if that were true, then of course we had no way to turn other than a minimal auto insurance policy for somebody who suffered serious permanent brain injury and serious damages because of this particular incident. So what we determined was I took the deposition of the gentleman who runs the company called Modern Alloy, and I asked them all about their business plan. Well, their business plan was they actually did work out on the 710 freeway. They were cement finishers working on freeways. So as you can see here, here's the workplace, but he was on his way to the yard. They made everybody come in and go to the yard, and then they would gather up, get into trucks, and then they would drive to the workplace. This gentleman was a cement finisher, so he could have gone straight from here to the workplace, but no, he's over here with fellow workers getting equipment to then drive out to the workplace, move the trucks, move people, move materials, and they turned him from a cement finisher into a truck driver. The Teamsters would not have been happy that they were using a employee cement finisher to be the Teamster who drives these individuals to the workplace. So we said it's not common. This is not a common to and from, not ordinary, uncompensated, even though it was regularly done every day. That's why the judge said, well, he does this every day. That's all part of his work. It's every day he goes there. Well, the fact that you do something wrong every day doesn't make it right. So the fact that it's common and done every day, there was a direct benefit to the employer. So I just wanted to say to you that the message of this case is don't give up, keep fighting for your client. And I'm going to give you a site that is not in the papers here, but I want you to look up the case. Of Sumrall versus 2 other appellate justices. They said this is a question of fact. This is a question.
And we'll send that out afterwards as well, what he's notating.
Yeah, we'll definitely send a site, for sure. And we've
A fact. So basically, we went from $0 to $9 million and changed this life of this individual. And Traci can tell us all the great things that would happen to the money that.
Yeah, this was a fun case too. And there shows a slide of how much and how hard he worked to get anywhere. Is that the end of your?
He received. And that's it. I think that's what I wanted to convey, that we can, don't give up, keep fighting.
Do not give up, and and this family, when I first met them, I was like, how long has your case been going on? It was definitely one of those. However, again, fantastic planning. This is one of the things I want to stress with this one. We did not have a special needs trust or anything like that. We were fortunate to not have to do that. However, one of the things that it was super important was understanding the risk tolerance. With a highly educated family, at one point in her life, the wife, Mrs. Sumrall, was actually a financial advisor as well. And it could have been something that, the clients or the Aitken firm could have said, well, they're smart, they can just take the money. But in this particular case, we really talked through risk tolerance. So we did end up doing a blend of both a structured settlement and also an investment account, as well as making sure we protected his entitlement benefits of doing a Medicare set aside. The family now lives close to their grandchildren. They purchased a home and built a home, actually, and also are purchasing rental property. So they're doing a fantastic job. They're smart with their money. We stay in very, very close contact with them. And again, it's very, very helpful. It really takes the point where I think all of us are trying to make, Wylie, Chris, and myself, is bring in the best team for everything, even if it's a complicated case. Don't hesitate to reach out to somebody like Chris or Wylie to work through the complications of a case, or myself on the planning part. But it takes a team, and I think we can bring them all to the finish line. And I just wanted to see if Chris, do you want to add any closing remarks or anything that you'd like to say?
I just want to say thank everybody for coming, for sure. It really is a team effort, and I really want to, and I tell you, Traci, I think, at least for our firm, I think we were the first people to meet way back in the day. I know you were before and it's really been a pleasure to work with you, because what Traci does is she cares, and she stays with the clients. It's not just a situation where you send up annuity and you say goodbye to the client. She provides so many different kinds of services. And I can tell you, because Traci, as you know, we use you all the time. when I hand off a case to Traci, I feel 110% confident on two things. One, it's going to be done the right way. It's going to be done. They're so professional, as far as what they're doing. Two, we can think out of the box. You saw in a couple cases here that people actually bought homes through these settlements, and there's a certain, not, thinking out of the box and trying to get that through a judge. Not every judge will say, hey, you know what? Yeah, go buy a home. There are complexities to that. And but working with Traci, that's been successful. And three, like in the Garrett Port case and other cases, I mean, you're talking, you're hearing real life stories of a client that, I represented 10 to 12 years ago. Time flies, but with Traci, she stays with the family, and that is just, I want to commend you, Traci. It's an invaluable service you give, and I just really appreciate everything you do. So my closing comment, in essence, is, we're really privileged to represent these clients. We're really privileged to work with a group like Traci gives to take care of these clients for life, and it's so satisfying to it is tragic. It always will be tragic, but it's so satisfying to try to put them in a better place. So that would be my.
Thank you, Chris. Thank you. And I can't say enough how important it is. And Wylie, maybe you can expand on this a little bit more, but to start your case with some of the end in mind. And I think you touched on, Chris, the judges and such too. It's super important to make sure that you're doing your case properly, because one of the things I'm very comfortable with, it doesn't matter anybody in your firm. I walk into the courthouse and we're smooth sailing. We've crossed our T's, dotted our I's. We know our case, we know our plan. Everybody's on board in the preparation. So by the time it gets to me, you guys have already done an amazing job there too. So Wylie, some closing remarks. And
yeah, I just have a simple closing remark, which is I look forward to.
You can add one for him.
Well,
to our next segment, and very difficult. They mean well, but the education and care of a judge is an important topic.
Yes, yes, yes. Well, thank you for everybody joining us today. Thank you, Wylie. Thank you, Chris. I look forward to seeing you in person sometime very, very soon, hopefully. And I'm glad that we have this world to do it. So thank you for joining us. And if anybody has any questions, please feel open to reach out to us. And we'll also send out to you the notes that Wylie had as well. And I'm sure the presentation is available as well. So thank you all and have a great day.
Thank you all.
Thank you. Thank you, everybody.